Thank you all so much for tuning in. This is attorney Matt Wayman here today to chat with you about the expungement of arrest records. I made a video a little while back talking about the expungement of convictions and also arrest records. This video is going to be specifically about the expungement of arrest records under Missouri Revised Statute 610.122, which is how we go about filing petitions for the expungement of arrest records. The people that qualify for these petitions are people that were arrested and never charged, people that were arrested and charged but the case was later dismissed, either due to insufficient evidence or the successful completion of a deferred prosecution agreement. And the people that would also qualify would be people that were arrested and charged and took their case to trial and then were acquitted at trial. They would also qualify. To be able to submit the petition for the expungement and actually have it granted, you have to fulfill a number of statutory requirements. The first one of those being that the court determines that the arrest was based off false information. We establish this by putting the petitioner on the stand. I would then question that petitioner based off the police reports to show to the court that something that the arresting officer relied on in making that arrest was based off false information. The next requirement is that there is no probable cause at the time of the action to expunge to believe that the individual committed that offense. Again, we would do this by questioning the petitioner on the stand to show that no charges were filed on this case, or that charges were filed and they were later acquitted of these charges, or that charges were filed and the case was later dismissed. Thus, there's no probable cause at the time of the action to expunge to believe that they actually committed that offense. The next requirement that would be that no charges will be pursued as the result of the arrest. You can establish this by waiting a long period of time after you were arrested. You can also do this by showing that you were arrested but actually never charged. One of the ways that we use for where the statute of limitations is a long time is I'll actually file requests for admissions with the prosecuting attorney's office to where they actually have to admit that charges aren't going to be filed in the future on this. The next one would be that the subject of the arrest did not receive an SIS or a suspended imposition of sentence for the offense for which they are arrested for, or any other offense related to that arrest. And we do this by the absence of records. So I would just question the petitioner and say, you did not receive an SIS for this arrest, right? And also you didn't receive an SIS for any other offense related to that arrest, correct? And they would say, no, I did not receive an SIS for that. And we would use that to establish that statutory requirement. The last statutory requirement necessary for the judge to grant your expungement is that there's no civil actions pending relating to the arrest at the time of the action to expunge. So again, I would just do this by asking the petitioner if there's any civil actions pending. And when that petitioner says no, I will then ask that the judge grants the petition for expungement on behalf of my client. I will then file a judgment and order form with the court so the judge can just sign it and grant the expungement. After that expungement's granted, that same judgment and order form will be sent to every party that has records of the arrest and order them to expunge their database of those records. I hope this video has been pretty informative about the intricacies of Missouri Revised Statute 610.122. If you have any additional questions, I do about 50 or 60 of these arrest record expungements a year. Just comment down below or give us a call. I want to thank you guys so much for tuning in. Please tune back soon for more videos. Thanks.